Welcome to TST Broadcasting and the Timeshare Resort Management and Marketing Channel. This is Shep Altshuler, publisher of TimeSharing Today. Regulations on overtime pay affecting non-exempt and exempt employees were put on hold by a federal judge just prior to those regulations becoming effective. George Leposky, TimeSharing Today's editor, joins us on this program to discuss his analysis of the current situation. Hi, George. Welcome to the broadcast.
Hello. How are you?
Fine, thanks. A lot of companies moved forward on the new U.S. overtime regulations. They were aware of it and implemented changes, but there are some changes in the status. So what is the status of the new regulations that were scheduled to take effect on December 1st, 2016?
The new regulations are on hold. That's due to an injunction issued by a federal judge in Texas on November 22nd. He acted on a lawsuit that was filed by 21 states and 21 business groups, including the U.S. Chamber of Commerce. They claimed that the Department of Labor doesn't have the right to reclassify workers as exempt from overtime or non-exempt, which means they're eligible for overtime, based solely on their salary level. Judge Amos Mazant III of the Eastern District of Texas agreed with them. So everything's on hold now.
Why don't you just provide a definition of what is overtime?
Good question. According to the Fair Labor Standards Act, a normal full-time work week is 40 hours. Non-exempt employees who work more than that in a given week are entitled to receive time and a half pay for the additional hours. Exempt employees, those who don't get overtime, may be required to work additional hours beyond the 40 without receiving extra pay.
What did the new regulations involve?
Well, the new regulations were a means of bringing the level up for people who had been classified as supervisors or managers and were not getting overtime and weren't making a whole lot of money anyway. In 2014, President Obama directed the Secretary of Labor to update these regulations. They were open for, the new regulations were written, they were open for comment, and both houses of Congress held hearings earlier this year, in 2016. For non-exempt workers, the Department of Labor raised the salary threshold from $455 a week, which is only $23,660 a year, to $913 a week, which is $47,476 per year. The Department of Labor said this would have affected 4.2 million workers who would have earned more money or gained more free time if they had their hours capped without allowing for overtime. In addition, the new regulations automatically updated the salary threshold every 3 years based on wage growth over time to increase predictability so they wouldn't have to go through this whole administrative routine of raising the levels again in 3 years or however many years until the next raise.
Now, how were executives, managers, and skilled professionals affected by this?
The Department of Labor calls these people highly compensated employees, or HCEs. They have a different set of rules which also were changing. Right now, an HCE who makes more than $100,000 a year is not entitled to overtime pay. The new limit was set at $134,000 a year. The new final rule also would have let employees count commissions and other non-discretionary bonuses and incentive payments towards up to 10% of an employee's salary. That would have affected timeshare salespersons who rely on commissions and bonuses for much or all of their income. The HCE exemption applies to white-collar workers, highly compensated employees, and also to outside sales employees, commissioned sales employees in retail, and a bunch of other people who don't typically work in the timeshare industry, including farm workers and drivers, loaders, mechanics, and so forth. In general, exempt employees must be paid a salary rather than an hourly wage, and they must meet the minimum, which would have been raised to $913 a week. Now, exempt employees must have duties that set them apart from the ordinary worker. They may have special knowledge or skills, like computer professionals, and or they may play a supervisory, managerial, or executive role. This means directing the work of other employees, and at the executive level, it means having the authority to hire or fire other employees. So that's what an HCE is.
What adjustments were being made before this injunction was issued?
Well, many companies were hiring labor attorneys, specialists in such matters who live and breathe Department of Labor regulations 24/7. They were looking for guidance on properly classifying employees as exempt or non-exempt. If you get it wrong and the government complains, you're probably in trouble. So labor employees suddenly became a highly desirable commodity. Developers, timeshare marketing and sales companies, and resort boards of directors who have an in-house counsel or a counsel on retainer shouldn't necessarily expect those people to have such expertise. So many were contacting consultants who specialize in labor law.
And how do employers optimize employee classifications?
No, the point about classifying employees as exempt or non-exempt means that you want to first properly do it and understand your other objective, which is to eliminate or at least minimize overtime costs. To do this under the new regulations, you would have raised the salaries of employees who were earning close to the new standard salary level of $913 a week. With their earnings above that level, they would qualify for the exemption. On the other hand, the salaries of employees who already earn more than $913 a week could have been reduced to hourly wages below $913 a week. Then they became entitled to overtime, except that you could have limited their hours to avoid paying them overtime. This, of course, would have had some other repercussions.
So how do employers limit overtime?
Yeah, to limit overtime, you have to write a policy, and the policy should require prior approval for an employee to work extra hours. This includes working from home or while traveling outside the office, working on weekends, and staying late in the office to catch up on work. Make it clear that employees aren't allowed to work extra hours without approval. Then you have to keep track of the hours that your non-exempt employees work. This means setting up an automated time system that records the time they spend working during normal working hours. Hopefully they're working during those hours, authorized break times, and other work outside of normal working hours. And to prevent employees from trying to bypass your approval process, it's a good idea to block remote access to the company's computers from outside locations and from smartphones. If the Department of Labor or the Internal Revenue Service audits your enterprise, such an automated system is the only way that you can prove you're following the rules. It may seem like an awful nuisance, but experts I've consulted tell me it's nothing compared to the penalties you could face without it.
Now, these measures do look pretty harsh. They'll put a damper on any company with a warm and fuzzy corporate culture. Is there any other alternative to this?
Yeah, there is. You can still follow the rules. You should still follow the rules, whatever the rules are, when they're in place. But you can minimize their impact on your staff and on your corporate culture by finding ways to improve efficiency and time management. When everyone stays focused and gets the work done faster, overtime won't be necessary. Now, if you don't know where to start doing this, look at the literature. Hundreds of books and articles have been written on these topics. Some of them are gobbledygook, but others make good sense, and you can probably find some guidance in the printed word somewhere. You could also hire a consultant. Some large accounting and business consulting firms offer assistance with business efficiency and time management. So there are also self-employed consultants out there who offer these services. Do some Googling and ask around to find someone suitable.
In the wake of the injunction, what happens now?
Good question. Nobody knows. The Labor Department could appeal Judge Mazant's injunction to the Fifth U.S. Circuit Court of Appeals in New Orleans. That's not necessarily as promising as it might be somewhere else, because the Fifth Circuit is a very conservative body. You may recall that in 2015, it blocked President Obama's executive orders easing immigration restrictions. It could view the new overtime rules with jaundiced eyes. Of course, after President-elect Trump takes office on January 20th, 2017, such an appeal could be dropped. But maybe Trump won't drop the appeal, and maybe the court will reverse the injunction. Then, eventually, the new rules, as written, could take effect.
And what do you think employers should be doing in the meantime?
Probably nothing. The uncertainty leaves employers with a dilemma. Many companies have already boosted the salaries of exempt employees who were just below the new minimum of $913 a week to a level just above it to keep them exempt. There probably haven't been that many reductions, because that would have aggravated the people whose salaries were being reduced. But the increases are undoubtedly out there, and I've heard of situations where that was exactly what the employers did. There have also been staffing adjustments made to limit the hours of non-exempt employees so they won't be paid overtime. And, of course, many companies installed or adjusted timekeeping systems and other software to implement the new rules. Rescinding these changes now would be expensive. It would be demoralizing to the workers who've just newly benefited and would then be adversely affected. And perhaps all of this would be temporary if the new rules are reinstated later. There's still another possibility. Some sort of compromise. Under Trump's administration and a Republican-dominated Congress, the Labor Department could revise or totally rewrite the rules. Now, that could require a lengthy decision-making process with another comment period and more hearings before a newer set of rules could take effect. So, with all of these ambiguities and uncertainties and a timeline stretching indefinitely into the future, the best course of action may be to wait and see what happens, while making no further changes in the meantime. And, of course, in that interim period, the genie is already out of the bottle. Companies that complied in advance with the new regulations have become more attractive places to work. No law says you can't pay employees more than what the government requires or give them a better work schedule. And companies that have done that in expectation that the government would require it, and now the government doesn't require it, they've still got it, they're ahead of the curve. And even without a change in the overtime rules for years to come, this rulemaking process has unleashed competitive forces in the marketplace. Those forces are likely to raise the tide anyway for many workers who would have benefited from the new rules. Some who already have, others who will very quickly figure out that maybe they should go somewhere else where the changes have already been made, even without the force of law to require them. So unless something very draconian and very adverse happens, this process probably will have a long-term benefit on the employment picture in the United States.
Just to be clear, a company, as an example, started implementing the policy for their employees, but they haven't gone through the whole process of modifying all the employees. They're in the process of doing that. I guess the assumption is if you started making changes, stick with those changes, even though this injunction is in effect, because you don't want to have employees in two different camps.
Yes and no. I mean, if you've got two employees doing the same job, and one of them got a boost above $913 a week, and the other one wouldn't have gotten it till next week, and they come to a screeching halt, and the other guy doesn't get it, and the two of them talk to each other, that could be awkward. If you have set out to implement a policy for certain types of employees who have certain requirements under the new regulations, and maybe half of them have already had the implementation done, the other half have not, for that, it's probably better to go ahead and just bite the bullet, do it all, and not have the possibility of people talking to each other and dissension in the ranks. You don't want to rescind the benefits that have been already provided to some or all of the workers, because that would cause them great grief, and probably cause the employer great grief too in the end.
And I guess the old adage, when in doubt, find an expert to give you sound advice. Would you agree with that?
I would agree with that, and I would also say, when in doubt, err on the side of being a good, upstanding human being and doing it forthrightly and honestly, and giving people the benefit of the doubt. They'll be better workers for it.
Well, George, thank you. I think you shedded some light on this, and I think the important thing is that those who are engaged in the employment practices at the various resorts have to stay on top of this very fluid situation.
Indeed. It's undoubtedly going to change from what it is now. The only question is, what will the changes be? When will they be? How long will it take? And how to adapt and adjust as those changes come down.
And this concludes this TST broadcast on the Timeshare Resort Management and Marketing Channel. If you have comments about this program, email staff@tstoday.com. Board members and resort managers are reminded to confirm your attendance at TBMA Providence, Rhode Island, May 21st through 23rd, 2017. Send your RSVP to resorts@tstoday.com.